Real people, real cases. This is Verdict Watch.
This courtroom scene features a man named Shane Harling facing serious charges in Dickson County, Tennessee. He's already in custody, and this hearing explains why. The judge brings up his past, including aggravated assault and illegal weapons, and his own attorney tries to quit the case during the hearing. Then comes a twist. Investigator Brad Shelton takes the stand. He's known across Tennessee for working undercover in high-stakes cases. One of those was the Angelia Solomon case. She allegedly tried to hire someone to kill her ex-husband. The hitman? Shelton, working undercover. So when Shelton testifies, it means law enforcement sees Harling as a serious risk. This case is more than routine. It's a look into the deeper world of criminal investigations across Tennessee.
All right, bring one out.
You don't need to touch the mouth.
Oh, I don't think.
All right, and
It's already on you. You don't have to touch it.
what is your name?
Sean Harding.
Good morning, Your Honor.
Good
Ryan
morning.
Davis for Mr. Harding. We have two motions pending today. One is a motion to reduce bond, in which the state does have one TBI agent that is here. That will be a brief motion.
He didn't say done, but he's got these people.
I am muting you at the jail until such time as I call on you, please. All right,
And I've also
I'm
got
sorry, repeat that.
this. I filed a motion to reduce bond on Mr. Harding's behalf. The state has one witness, a TBI agent that is here. I think that'll be a relatively brief hearing on the motion to reduce bond. And then I've also filed a motion to withdraw as counsel, which I think would need to be heard second. And so I'm happy to assist Mr. Harding with the motion to reduce bond whenever the court's ready to have that heard.
Well, if you think it's going to be a short motion, we'll go ahead. Is the state ready to take up this motion for bond reduction? Well, since he's here and in custody, I'd like to go ahead and deal with it if we can.
That'd
All
be
right.
fine, Your Honor.
We'll give you space at the table. Just shove all that stuff that the public defender has on that table out of your way. All right, Mr. Davis, I understand you want to argue the motion for a reduction of bond before your motion to withdraw, correct?
Mr. Harding has been in custody for a couple of years now. This is one of the conspiracy cases, and despite that, a motion to reduce his bond has never been filed. That being said, he has made the best of his time while in custody. Attached to my motion, he's completed several courses, and Career Academy course in Enduring Skills, another course called the Master Plan, The Only Person You Cheat Is You, and then also an electrical course, and so some job readiness, and he's made good use of his time there. He also has been accepted, most importantly, Exhibit B to our motion, has been accepted into the Cross-Style Center for a year-long residential treatment and recovery program. The acceptance letter was dated March 7th, so this we filed this motion as soon as, and set it as soon as possible once he was accepted into that program. Based on other cases that have been heard today, it appears that his plea settlement deadline is going to be September 22nd with a trial date of late January. And Your Honor, this is a much better use of the taxpayer resources of this county for Mr. Harding to receive not quite a year, but even if he were to be convicted at trial, several months of rehabilitation and treatment in a residential facility that he's required to remain on campus, and certainly the court could put appropriate conditions on that release. But he needs the bond to be set at a significantly more reasonable amount in order for his friends and family to be able to make that bond for him. So I believe he's demonstrated the best conduct he can while in custody, as well as acceptance into a program. He's not asking just to roam free in the community. He's asking to get treatment, and I think that's a better use of resources, and that would be our argument. And at this point, I don't intend to call him as a witness unless the court sees fit.
All right, your argument is, your case will be based solely on your argument, and he has a charge of driving on a revoked license, second offense, unlawful drug paraphernalia uses and activities in 2023 CR 10, and then, if I understand correctly, according to the docket, he then has a case of, that's the conspiracy case,
Yeah,
300 grams or more, and then he also has another separate indictment of 2023 CR 19, charging him with possession of methamphetamine with intent to sell, unlawful drug paraphernalia, and resisting arrest. All right?
Yes, Your Honor. I've got four case numbers.
Right.
It's
There is
possible I
another
missed one.
case of possession of methamphetamine with intent to sell 0.5 grams or more, possession of heroin for resale, possession of a weapon by a convicted felon, possession of firearm during a dangerous felony.
Yes, Your Honor. All 23 cases, I've got numbers 10, 19, 21, and 62.
And what is the aggregate total bond that he has?
$235,000.
All right. I've heard your argument. We'll allow the state to respond. All right, call your first witness.
I do.
Can you please state your name for the record?
My name is Sean Adkins,
And where are you employed?
Tennessee Bureau of Investigation.
And did you participate in a multi-agency investigation involving a wiretap?
Yes, I did.
And who was that wiretap on?
It was on the Dantes Good drug trafficking organization.
Okay. And during that time period, are you familiar with whether or not Mr. Harding was arrested prior to the conspiracy?
Yes, ma'am.
And do you know what he was found with during that time period?
The first I learned of it was in, I believe, September of 2022. He was arrested for possession of methamphetamine, heroin, and a weapon.
Okay. And are you familiar with how much methamphetamine he had?
Yeah, it was estimated that it was over 100 grams of methamphetamine. I don't know what the exact total was when it came back from the lab.
Okay. And you said that was on September 26th of 2022?
Yes.
Okay. Were you able to, was Mr. Harding on the wire at all in the Dantes Good organization?
Yes, he came up in the wire around December of 2022 and through January 3rd of 2023 multiple times.
Okay, and can you tell us what it means by that he was on the wire? Explain what his participation was.
All right, during the wire, we were listening to the telephone of Dantes Good, the primary target of this drug trafficking organization. We identified a number coming from Sean Harding, where he contacted Dantes Good to arrange drug purchases.
And would he travel to pick up those items?
Yes, ma'am. He traveled to Davidson County.
And was he seen on surveillance during that time period?
Yes, ma'am.
Okay. And looking at the wire purchases, are you aware of how many purchases of drugs and the different types of drugs during that? I think you said from September to January.
Yeah, between December 2nd and January 3rd, we intercepted approximately 10 phone calls or conversations between Mr. Harding and Dantes Good, during which drug transactions were arranged. Those transactions included methamphetamine and heroin, or fentanyl at this point. The total of those transactions that were arranged or talked about resulted in, combined was 29 ounces of methamphetamine and 10.5 grams of heroin fentanyl. And when I said they were arranged, the conversations were set up for a price, an amount, sometimes not a price, sometimes not an amount. Sometimes it was understood between two individuals what they wanted and what the price would be. But it was where the conversation further supported that they did meet to exchange those drugs. And on the January 3rd occasion, we actually had the surveillance out where we saw Sean Harding in a vehicle meet with the Dantes Good organization and pick up methamphetamine.
And was he later found that same day with methamphetamine?
Yes, ma'am. Later that same day, he was traffic stopped on Highway 46 near Interstate 40 here in Dixon County, and he had approximately 4 ounces of methamphetamine on his person.
And I would presume that the quantity of drugs that Mr. Harding was purchasing, in your experience, is not for personal use.
Those quantities are usually for resale, not for personal use.
And are you aware of whether or not Mr. Harding made any admissions in this case?
Yes, in January, or in the September incident, he stated that you got me, and I believe he also spoke to agents at that time in September.
Okay. And did he admit to selling the narcotics during the conversations?
Yes, ma'am.
Thank you, Judge. I don't have any further questions.
Mr. Davis, you may cross-examine.
Good morning, Agent. My name is Ryan Davis. I represent Mr. Harding. When Mr. Harding was apprehended, he was also found to have needles on him and signs that he'd also been using, correct?
Yes, I believe in the September incident, there were needles found in the car.
Okay. And it's not uncommon for someone to sell to support their habit in
No.
your line of investigation.
No, sir, it's common.
And you believe that that was probably the case for Mr. Harding?
Usually with most people that we investigate, they're also users as well as distributors to fund their habit.
Okay. Nothing further, Your Honor.
You redirect? Thank you. You may step down.
Thanks, sir.
Any rebuttal?
Despite the state's evidence, the purpose of bond, and I understand one of the factors in a motion to reduce, or factors in setting bond and reducing it, is likelihood of conviction. But Mr. Harding is still presumed innocent. Even though he's wearing orange and he's been in custody for a couple of years, his presumption of innocence carries with him all the way until trial. And there are multiple factors for the court to consider, including his time in the community of almost 30 years. He was gainfully employed in ways other than selling, the allegations of selling drugs.
He's not a resident of Dixon County for 30 years. He's a Davidson County resident.
Well,
correct?
resident of Tennessee, Your Honor, and nearby, and with longstanding ties in the community. And the purpose of bond primarily should be to secure a defendant's attendance back at court. And I believe it can do so here. And again, he's made best use of his time, and the community is better served by Mr. Harding, who, again, if the state is able to prove these allegations, I think the proof at trial will show he was trying to support his own habit. So allowing him to attend and complete a residential treatment job readiness program with a high bar of accountability is a better use of the taxpayer resources, and we believe a significant reduction in his bond is appropriate.
Your Honor, I would just argue that there has been no testimony showing Mr. Harding's ties to the community or his previous employment. The only testimony I would argue that's been shown, other than obviously the certificates that were provided, is the fact that Mr. Harding was on multiple occasions found with and on the wire purchasing large amounts of methamphetamine as well as a fentanyl, heroin fentanyl. These obviously are serious charges, Judge. I believe there's strong evidence that would show that we could convict Mr. Harding of these charges. In fact, the fact that he was admitted that he was buying and selling the drugs, these are Class A felony charges, at least in regards to the conspiracy case. He's looking at 15 to 25 years or more, depending on his range of punishment, Judge. And I would ask that he not be released due to the fact that of all the different charges, Judge. And I believe it also to bring to the attention that on 9/26/22, I believe he was found with a gun. I think that because of the seriousness of these charges and because there is a danger to the public due to the fentanyl and the gun, I would ask that the court keep his bond the same.
In considering the request for a bond reduction, I'm required to look at the factors that are set forth in 4011-115 of the Tennessee Code. Those factors are as follows. The defendant's length of residence in the community. This court is of the opinion that his 30 years of being a resident of Davidson County don't qualify him to be a resident of Dixon County community, and that's we are not an adjacent community. We are sometimes considered to be a bedroom community of Davidson County, but I don't think his 30 years of living in Davidson County qualifies as being a resident of this community. That factor is not a factor for the defendant. The defendant's employment status, I understand there's not really any evidence that's been presented. His prior criminal record, including prior releases of recognizance on bail, I don't have any evidence about that. Whether at the time being charged with the offense, the defendant was on release pending trial or sentencing, there is I don't find anything that indicates that. Just have a seat, Mr. Davis. The nature of the offense and apparent probability of conviction and the likely sentence. This is this conspiracy charge is a Class A felony. That's the 2023 CR 21. In addition to that, he has other charges of possession of methamphetamine, which are Class B felonies at the minimum. In docket number 2023 CR 62, he has a Class B felony of possession of methamphetamine with intent to sell, possession of heroin with intent to resell, and then possession of a weapon by a convicted felon and possession of a firearm during a dangerous felony. The testimony before the court is that not only was he found in possession of these items, but he made a confession or admission to investigating officers. But in addition to that, he was on record on the wiretap tapes as having made arrangements to purchase large amounts of methamphetamine. So the type of charge, the nature of the offense, and apparent probability of conviction are high. If he is convicted of the conspiracy charge, then he's not even eligible for probation, and which is a factor the court has to consider. That would be a strong motivation for someone to abscond if they are released on bond and the bond was lowered. I don't have any other indicating that there's any other factors of ties to the community. Based upon the foregoing, it is this court's opinion that the motion to reduce his bond, despite the fact he may have been in jail for some time, we've now set a final plea day and a trial date for him. So that is, in my opinion, the motion to reduce bonds should be denied.
I do want to clarify for the record, as stated in my motion, and I thought maybe the court had something before it that I didn't, but Mr. Harding has confirmed he's been a resident of Dixon and Hitman County.
There's no evidence. Stating something in a motion is not the same as evidence at a hearing. So
I understand, but the court is if the court is basing its decision, at least in some part, on
I'm
residency.
considering the evidence at trial.
Thank you, Your Honor.
At the hearing. So I have denied the motion to withdraw. The case is set for trial on January the 20th of 2026, and the last status day will be September the 22nd of 2025. Mr. Davis has filed a motion to withdraw, and I've reviewed very quickly your motion to withdraw. I'll allow you to argue it if you wish to make any argument other than what set forth in your motion.
Your Honor, I'm happy to rely largely on my motion, but this was an appointment that I did not seek, that I was not asked if I would like to be appointed to this case. This is a complicated case. I think the likelihood of Mr. Harding proceeding to trial is quite high. In January, with the caps on compensation, is not only a case in which counsel is unfairly compensated, but no doubt a case in which I would lose a significant amount of money trying this case. Dixon County, although I love being before the court, is an hour from my home and an hour from my office as well. In order to take cases here, I charge appropriately, retain clients. I'm not going to belabor the 14-page argument that I made before the court, but the rule does, while the rule does provide for involuntary appointments, it also provides for a basis for withdrawal if there's an unreasonable financial burden. I've set that out in my motion, which certainly is the case here. Not to mention the fact that the section of the rules of professional conduct that allow judges to appoint involuntarily does not single out only attorneys that take criminal appointments. I would think there's.
Walk behind instead of in front. Walk behind it instead of in front of it.
Thank you, Your Honor. I thought maybe you were laughing at me. I mean, I'm really trying hard here, Judge.
Right.
But the rule that allows the involuntary appointment does not contemplate only attorneys that practice criminal law. There's, I would venture to say, a lot of other licensed attorneys in Dixon County that have yet to be appointed to represent defendants in this county. But for the reasons set forth in my motion, which I'm sure the court has read, I'm asking to withdraw just because this is something that I cannot afford to try a week-long conspiracy case at the rate in which the Supreme Court of Tennessee values my services. This is a problem that the Supreme Court of the state has been attempting to address, and part of that was the administrative office of the courts and the Tennessee Supreme Court have both worked together to try to raise the minimum rate for lawyers who are appointed in criminal cases. I have stood in the same shoes that you have been in, Mr. Davis, for many years. I've taken cases when I was practicing law that I didn't want to, and I had a net of $50 in a first-degree murder case back in the 80s that it was certainly not something that I had asked for, and it was an involuntary appointment. The problem that we have is that it's a 27 defendant indictment. Therefore, the public defender cannot represent more than one, if possibly even that one, and we had to reach out. There are not 27 criminal defense lawyers in Dixon County who are practicing criminal law. I understand your argument about other attorneys in Dixon County who have not been assigned it, but in truth, we have assigned cases or appointed cases to every lawyer who practices criminal law in this county. We don't appoint people who do not practice criminal law for the very reason that they're not competent to, particularly competent to be able to take an appointment and try that case. So what we've had to do is to reach out to anyone who practices criminal law in this court. If you take a criminal law case for pay in this court, then you're subject to being appointed. This is just unfortunately a very complex case. If I relieve you from representing this defendant, I have to then turn around and find someone else to represent him, and it will be in the same scenario that we're already in. I've already exhausted every known person in the area that regularly practices in this court. So I understand your motion, I understand your basis for it. I'm sympathetic, but I cannot grant your motion to withdraw solely based upon the financial burden it places upon you. And for that reason, I must respectfully deny your motion. As I say, I think this may be a case where we need to try to have something done that raises the level of what the attorneys who are involved in this case, because of the complexity of it, may have to try to get with the administrative office of the courts to try to see if there's some way to alleviate that cap or raise the cap on the case that would allow you to be compensated more regularly. I think you can file a motion for a case to be considered to be extended and complex, and it certainly is. In any event, I'm certainly willing to assist any of the lawyers in seeking compensation beyond
the cap that we have. But I will be required to deny your motion with regret, so.
I'm not going to continue asking for a different outcome, but I would say that the rate, whatever it was you were paid in the 80s, that rate was actually fairly similar to what the rate is now. And if you factor in, the inflation, you actually were doing quite better in the 80s than I'll be doing on this case.
They paid, for when I was appointed to represent Ada Whittemire on a first-degree murder charge, Judge Leonard Martin appointed me because I was a young lawyer and he thought that would be good experience. Well, our main proof consisted of Dr. R.D. Garcia, who was chief forensic psychiatrist in Oklahoma, who opined that she was paranoid schizophrenic and could constitute a defense of insanity. Problem was that she told me she had money in this is the Lonely Hearts Club killer. She corresponded with men and then married them and poisoned them. In any event,
Allegedly.
she told me, well, I think she was convicted of two of them, so we're going to go past the allegedly part. She told me she had $1,000 in her inmate fund at the DeBerry Correctional Institute so I could pay for Dr. Garcia to come up and testify in Dixon County, and I did. I bought him a ticket that was $450 for a round-trip ticket for Dr. Garcia. And during the trial, District Attorney Kenneth Atkins filed a motion to have the court hold that inmate account should be seized because she had obtained that money from a wealthy rancher in Canada, corresponding with him from the DeBerry Correctional Institute, saying she'd come up and take care of him if he'd give her the money to transport. So they seized that money, so I paid $450 out of my pocket. I made a $500 cap because it was a non-capital case. So I, for a 2-week trial, made it $50 net. So
I understand, Your Honor, and there are examples where if there's an area, for example, I have particular specialty in issues regarding sex offender registry and post-conviction issues, and I took a case pro bono. I requested to be appointed to a case out of Davidson County, out of Williamson County, where I reside, to assist a public defender with a PCR on an issue that I took, and my cap is $1,500 on that, and I paid $1,500 out of pocket to have Dr. Kimberly Brown testify. So I believe in doing these things not only for the purpose.
I know you do, and you appear in front of me on a regular basis, and I have no question that this is not something you're trying to shirk your responsibilities, but it is generated solely because of the absolute impact that it has on your practice, and I regret that. And if there was a better solution, I would take it.
I understand.
If I had something I could do that would protect your client's rights and also protect your situation, I would do that. But unfortunately, I cannot.
Just for the sake of the record, I know we got a record being built here. I know the court mentioned getting with the administrative office of the courts. Well, in the Supreme Court and the AOC's infinite wisdom, they are propping up, and I'm sure the court is aware, will be made aware soon. They've now decided that the solution to the issue before the court is to create an office of the appointed counsel, in which they're going to basically require attorneys that want to take these cases in each county to have a contract. Unless it's a capital murder offense, it's just a fixed fee by another name. They're going to have a contract with a certain amount of cases that they agree to take each month, with a fixed rate that they're going to be paid each month. So they're not willing to fund it because they don't think the legislature is ever going to approve something that would be akin to what the federal courts pay. And that system works pretty well. You get really good representation with appointed attorneys in federal court. They're not ever going to fund that, so now they're going to create this contract system where you agree to take so many cases for a certain amount of money per month, which does not promote justice, does not promote zealous defense, and that's their solution that they're getting ready to spend the next 2 or 3 years rolling out.
I'm well aware of what they're moving towards, and I'm also very well aware of the impact that it has on a private practitioner to have to take a complex case like this. And I don't know. I wish I had a better solution.
Well, one of the solutions, and the reason my motion is 15 pages long, and it has nothing to do with this court in particular, but we might leverage the denial of my motion as an opportunity to litigate this elsewhere, because I think that's probably going to be the only way to get the state's attention. Well,
Mr. Harding, I want you to understand that Mr. Davis is a very fine attorney and does practice regularly. The problem is that because you are in custody and not able to hire your own lawyer, we have to provide you with counsel. Because of the complexity of the case, it places a huge impact financially and on the lawyers who are appointed in this case. And as a result of that, he is asking for nothing more than consideration by this court. But it doesn't mean he won't do a good job for you. It's simply. Well, I understand that, and I've considered the evidence, and I've denied your motion for a bond reduction for the reasons that I've stated. That's the judgment of the court. Thank you.
Thanks for watching Verdict Watch. New court drama every day. Don't forget to subscribe and turn on the bell so you never miss a case. Leave a comment with your thoughts. We're watching too.